Okay, Mark East with the State Medical Association. I'd like to welcome everyone to this presentation. This presentation is going to be Understanding an Employment Contract. We're going to discuss the quality of life issues. This is the third presentation of 5 programs that we have dedicated to physician employment issues. I want to make a note that I'm going to try to keep all phone lines open. However, if we do get a bunch of background noise, I will go ahead and mute the lines. But then towards the end of the presentation, we'll take a pause and we'll open them up for questions. I'm going to go script here just a second, and I want to introduce Wes Cleveland here with the American Medical Association. I have had the privilege of working with Wes over the years. He is truly a valuable resource. He's a great person to work with, so I know we're in for a good presentation this evening. So with that, I would like to go ahead and introduce Wes Cleveland. He is a senior attorney with the American Medical Association. Because Wes has such an extensive background, and he's involved in so many activities with the AMA, I'm actually going to ask Wes to introduce himself. So with that, Wes, I'm going to turn it over to you and ask you to lead us through tonight's discussion.
So much, Mark. Just a few words about myself. I've been practicing for over 20 years. Worked at Attorney General's office, then for the Texas Medical Association, then in private practice, and now at the AMA and its advocacy unit, state advocacy, also do some federal work as well, managed care, ERISA, fraud and abuse, payment models, physician contracting, whether it's managed care or employment agreements. And now we're also doing an awful lot of work in antitrust, especially with respect to trying to take on the big mergers between Aetna and Humana and Anthem and Cigna. So during my time at the Attorney General down in Texas, and there for a couple of years early in my career, the rest of my career has been spent representing physicians in varying capacities, and it's very rewarding, and it's good work, and it's a pleasure to represent the docs. So thank you for letting me be here with you tonight. So let's get started on this. Talk about, again, contract terms, again, focusing on some of the quality of life issues that are described in the publication that was, not the publication, but the notice of the webinar was about medical liability, duties, things like that. First, we'll start off with term and nation. Basically, when we talk about term, we're talking about, what I'm using the term here is I'm talking about the initial term of any contract you're going to be offered. So any employment agreement offered to you by a medical group or by a hospital. So just for a physician who's considering an employment offer. See some sample language there. The thing to look out for here is when the effective date of the contract is and starting date. For especially physicians just coming out of their residency and finishing their training, you just make sure that when the contract starts, they have sufficient time to get credentials, get your provider numbers, and so forth. But sometimes that can be a rather time-intensive process. You know, the initial term of a contract can last, you know, in medical groups, sometimes we frequently see 2 to 3 years. In health system contracts, you may see 3 to 5 years for initial term. You'll see then, so that's the initial pay agreement. Typically, what we will see often in contracts is then there is an automatic renewal provision. Sometimes this will be referred to as a rollover provision, or a lot of times you'll hear it referred as an evergreen. So in this situation, the contract will automatically renew for succeeding terms unless someone wants to terminate or not renew the contract as specified in the provisions of the contract. So that's just covering the terms. Relatively simple, difficult provisions. We're getting into termination, and this, you know, there's going to be a lot of things in the contract that, you know, the physicians, that a physician owner or an employee quibble with. You know, you're never going to get the perfect contract, right? But you want a good one, and you want one that's fair. So what I've tried to do is try to hit really the highlights in terms of quality provisions. So you focus on these are the major ones. Other ones you could quibble with, but they're not going to be that important. So we're talking about termination here. Now these be easy to spot in the contract, but the employed physician wants to be cautious. It's fair and that not too much power resides with the employer. So, for example, physicians should be prepared by any language that talks about termination. So, two types of termination. There is without cause termination, and then something else we call for cause. We'll take those each in series. So I have some sample language here if you want to take a look at that. Very typical. And here it said, employer may terminate this agreement by giving no less than fill in blanks advance notice to the other party, to, let's say, the employed physician. We see typically advance notice could be 60 days, could be up to 120 days. If you're the employee, you'll want to have, if you're going to err, you probably want to err on the side of having a longer notice period if he wants to terminate. Again, without cause means I'm going to end the contract. Doesn't need to be a reason for that. Okay. Why the employed physician might want to have a lengthier advance notice period is to give him or her an opportunity to seek other employment opportunities, which may necessitate the physician becoming credentialed in their plans. Okay, and we know how long that can take. Be very lengthy. So keep that in mind. We want to make sure that the physician has sufficient notice to be able to begin that process and hopefully reach a conclusion. Sufficient so that the physician can hit the ground running and start working at the next employer. Okay. Now this is what you might call a unilateral will cause termination provision. Typically what you would see in an employment contract offered to the physician is something that would be equal or reciprocal. Okay. So what you'll probably see in a contract is that not only does the employer have a right to end without cause termination, but should as well. You see that in the contract, but you want to make sure that it's in there. Just if it doesn't get in there because of oversight or something else, make sure it's reciprocal. Okay, so before we leave without cause termination, something I'll bring up. When you have an initial term of a contract that goes for 3 years, then you have a without cause termination provision in there that requires notice by the employer to give the employee 90 days in advance of the termination. How is the contract actually? It's 90 days. Okay. Because the employer or the employee can terminate the agreement in 90 days, notwithstanding how long that initial term is. Okay, here's our next basis for termination. We talked about without cause. Now we're talking about for cause. Sometimes this is automatic termination, and the difference between those two. Okay, for cause termination can sometimes be automatic termination by the employer. It's for specific causes. The ones I've listed here are very, very typical. Then licensed to practice in any state expires. DEA license is revoked or restricted. One thing I want to bring up about number 3 here that I think could require some elucidation. So, physician's membership on the medical staff of an employer, clinical privileges or employer are revoked or restricted in any way. One thing, if you see that you could think about, if it's important enough to you, it may be to add language onto that might be resulting from an intentional act or wrongdoing on part of the physician, so that run into the situation necessarily that you might have clinical privilege that might be terminated because of ending an exclusive contract or something like that. Another very common basis would be the employer is unable to maintain or maintain liability insurance. Here, I'd like to bring your attention here. Another basis is physician is convicted or enters a guilty plea or no contest for a felony crime, because it says, or any other act of moral turpitude. Now, that can be common, but also be problematic for the physician. We don't necessarily what moral turpitude is. As I'll emphasize again a little bit later, for the termination provisions like this, we want them to be as objective and broad line as possible. And that's the advantage of the way these are listed. For example, is if a physician is excluded from governmental payment programs, illegal substances, you can see that in the next last, and then physician's certification is revoked or restricted. Right, now, I'll take a look at the third one from the bottom. Audit termination would apply except for the for-cause basis that, like I said, is third from the bottom. You'll find this provision, or you should find this provision in your employment agreements as well. And this is for-cause termination. And here's very typical provision you might find in an employment agreement, which says you can terminate the contract if the physician fails or refuses to perform or fulfill any of the physician's duties, and the physician does not cure the breach within, we'll say, 30 days of the physician's receipt of notice to see such breach in detail from the employer. Okay, what's important here is that the physician is performing in accordance with one of these duties. And this could be important because sometimes the duties may not necessarily be specified just in the contract. They might be, if you're talking about a hospital system, you might have some of the duties that could be spelled out in policies and procedures that might be incorporated into the contract or referenced by the contract, but might not be specified in there. So it's really important that a contract won't be canceled or terminated in a case like that. The physician has a chance to be informed about the problem and say, oh, okay, well, you're going to give me 30 days to fix this. Okay, and if the physician does fix that, the contract continues. Now, had for-cause termination by the employer, we want to see some for-cause termination by the employee. And again, you have the for-cause cure type vision as first provision in there that's mentioned. Again, going to be reciprocal. If the employer refuses to perform or fulfill any of employer's duties, you want 30 days in there. You'd want something that's reciprocal on both sides. So if the employer isn't living up to its responsibilities, not marketing the physician as was represented in the contract, well, the physician can inform the employer, let's say it's a hospital, so forth, and then the hospital then could perform marketing duties, so long as it got it done within 30 days or whatever. Cure period is mentioned in the contract. And we have some things on the provider side that we saw on the physician side. some issue with employer's certification and accreditation, excluded from Medicare and Medicaid. Other thing that we do suggest in some of our materials is that a basis for cause termination would be if the employer files for bankruptcy. The physician isn't stuck in that situation for good. The notice period for the employer and the physician should be equal in terms of the cure provision. You know, one thing I want to mention to you all that might be a little bit more protection if you're thinking in terms of a potentially employed physician. Sometimes we see when it comes to economic issues, the cure rate is less. So let's say who is in position and paying the physician, let's say a base salary, supposed to be paying payments every month, and it turns out that the hospital misses a payment, say the first of the month, that basis of a notification of a breach that needs to be cured. In those cases, we would suggest that instead of maybe having the 30 days that might apply to other breaches, you might have that even reduced down to 10 days. So cure period, like I said, that's just one example, is often short for talking about economic issues. Okay, so now from the perspective of the employed physicians, one thing to watch out for are cases where cause on the employer's side is so broadly defined as to give the employer unlimited discretion to terminate the contract for cause. Because what that would do then, if it's so broadly defined, in a sense, it almost turns it into a without cause provision, so that there's protection for the employed physician. So when your termination for cause provision, you know, use employed physician or employed physician's lawyer, etc. Need to read that language carefully. Okay, make sure that the employer doesn't have too much discretion on determining whether cause exists. To the employed physician really needs to seek grounds that are as narrow as possible, carefully defined and limited. Good examples of that in the previous slide, which are very typical, and you also want to have that cure provision as well. So the physician isn't just out the door for cause in 30 days without the opportunity to address whatever deficiency the employer might think exists. This is a hot issue that you'd like to see addressed in a contract, and this would be not only in a case between hosts, let's say, or a health system and a physician, but also in groups, right? We've heard this time and again when physician groups have gone separate ways. You'll hear this frequently. People will say, who owns the patient records? Maybe who owns the patients? That is an area of significant dispute. Some states are actually addressing this issue now in laws about what the procedure is to be followed, how this is to be provided to patients, and so forth. But this is something that you would want to think about. That if a contract is terminated by either party, who's going to provide the notice? What's it going to say? To what extent is the departing physician going to be able to have access to patient lists and records? Okay. And possible negotiated provision that allows the physician to notify his or her patients upon termination of the agreement. So that's certainly a possibility that we see in an agreement. Something to think about really on the front end, okay, because you know, that some of the big issues are, okay, compensation, obviously, things like that when you're in the agreement. It's always really important to think about what's going to happen if this doesn't work out, because you try to get the best fit possible. But Management can change, leadership can change, people can retire. The situation just can completely change. And so it's important to think not only of what life's going to be like there, but what is going to, if you need to unwind the agreement. Okay, so now we're talking about duties. In the employment agreement, usually there's not a whole lot of description about duties in the contract itself. What you might find are duties more specified in exhibits that might be attached to the agreement and incorporated into the contract. I think I've listed at some of the issues you want to think about, or that I frequently hear physicians thinking about or asking about. Obviously, the big one is call responsibilities. And, I mean, the question you would want to ask here is how is call assigned, and the employer will want to probably have as much discretion as possible to assign call. At the employed physician standpoint, goal typically is for the employed physician to be obligated to provide call on an equal basis. So that's kind of what for physician advocates, what we consider to be a very pro-employed physician, equal call rated across all the other physician employees. It is actually becoming, and I'm talking about hours here, what's going to constitute full-time. Now, what's interesting now that we've seen various market developments of urgent care centers, minute clinics, things like that. Some physician groups and hospitals and other physician employers are really having extended hours. So evenings, Saturdays, and Sundays. So that's really something to think about, what your obligations are going to be. If you're just thinking about 9 to 5, the employer may have something else in mind. Again, to share equal responsibility there with the other positions. Administrative duties is also becoming, I think, an increasingly issue, especially when you're talking about more graded environments, clinically integrated networks, and things like that. Many times, it takes a lot of work not only to put those networks together and to implement protocols to monitor compliance or adherence or performance with respect to protocols, counting physicians on their performance and so forth. A lot of that, whether you call it administrative or administrative clinical, it's not direct patient care. But a lot of committee work many times in those sorts of situations. And so the question there would be, what obligations going to be, and are they going to be, again, apportioned throughout the specialties or the physician employees? There's going to be some compensation for that. Questions? Oh, one thing, you talked about the exhibit here, that's good. Oh, one point I want to bring up. That there may be some courting of the physician by the employer. And the lines can be said by the employer to the prospective employee. Okay, a lot of promises might be made. The important thing is to remember, and it's a contract rule, contract law that applies across the board. But if a promise doesn't make it into the contract, and doesn't count. It's not an enforceable promise. Okay, so the only thing that matters, what makes it into the contract, and not is just said. So keep that in mind too. And we'll talk about some medical liability insurance. This, unfortunately, is a continuing issue for physicians, no matter age. What you're actively practicing, it's always a concern. And of course, how much of a concern will depend on in many cases, what state you're in. Some states, California, have some pretty strong caps. Other states, not so much. Let's say like Florida. So you can see great variation in the insurance premiums and how much it costs the physician or the employer to carry insurance. Some of you may know this, but there's two types of medical liability insurance. One is occurrence coverage. Sometimes you hear it as indemnity-style insurance, but it covers any claim that arises based on alleged act or omission that occurred when the policy was in place, regardless of when a claim was filed. So let's say if the physician is insured in 2010, let's say, the policy isn't continued past 2010. The claim filed in 2012, it's covered under an occurrence policy. So, that one type, it doesn't make a difference when the claim was made by the prospective plaintiff. In other words, it's nearly as common for physicians as claims made coverage, only because the coverage is typically more expensive than claims made coverage, and I'll talk about claims made coverage. Made insurance covers only claims that are made within the policy period. Okay, that's like occurrence coverage. Also have to be filed within that same policy period. Okay, so it's the difference. It's less expensive than occurrence policies, at least initially, because especially when the physician is starting out, there's just not that much time period initially for potential liability to build up. Now, the drawback of a claims made policy is that once the policy is lapsed and it isn't renewed, there's more coverage for any claims that relate to the contact in the policy term but aren't filed until a later time. So, in other words, it had coverage, let's say, from 2000 to 2010, all right, and a claim was filed in 2011 or for some conduct that occurred between 2000 and 2010, that would be covered by that policy. So, a number of ways that a physician can address that lapse in coverage, and most typical of what is commonly referred to, technically you'll hear something like a reporting endorsement. In more vernacular language, it's just tail coverage. And tail coverage provides coverage for claims arising during the period the policy was in effect, but there was no claims filed. Sometimes, but I don't want to get into the details too much about that, but a way to provide that coverage is something to nose coverage as well. Okay, how do I bring this up? Okay, the tail coverage is an important issue, and probably because it can become expensive to the physician. And so I may make it an issue is that frequently, or almost always, right, if they're in an employment agreement, various sections, right, sections that'll be, entitled compensation, nation, notice, duties, this will be a provision, insurance. And they say, the employer typically will be the party that's purchasing insurance for the employee physician. Okay, that's typically how it works. It doesn't say that. It might say, the coverage limits that are being purchased, and it might get into that specificity. Frequently, though, that provision does not talk about coverage. All right, so that's important to bring up with the employer. Once that issue is raised, then there's the discussion about who's going to pay for that. So there's three options here, and again, this is just kind of general. you can come with all kinds of solutions to that issue. So, say one of the frequent things we see between employer and employee is the employer pays the premium while the employee is working employer, but the employee then is obligated to purchase the tail when the employment ends. Right. That's one way we see that. Sometimes, and here's when the nose coverage issue comes in, employer might cover that lapse in coverage. In that case, it's called nose coverage. So this would be an example where an employer might pick up that insurance obligation. Sometimes allocation of the tail premium cost is different. Important thing, if the employed physician leaves voluntarily, if the physician is terminated not for cause, or employed physician is terminated for cause. So for example, here could be an example when we're talking about termination by employer without cause. So some lawyers representing individual physicians who are negotiating with a potential employer might say, okay, I understand you're concerned about the tail coverage. Here, there might be taking the position that that to be the obligation of the employed physician once he or she leaves our employment. The representative from the employed physician could say, well, now wait a second. If my client, our individual physician, is going to be leaving his or her location, traveling, moving to work your organization, then the employer shouldn't be able just to say a month later or 2 months later, we're terminating and you're going to be responsible for coverage. Okay? It can be that physician has a period of time. Not going to be the concern if the employer would terminate without cause. You might even extend it to say if the employer terminates on a without cause basis, you could negate that and say that does not apply. That might not trigger an obligation on the part of the employed physician, or probably a stronger case would be to say if the physician had to terminate agreement for cause, that it was I guess you had fault in that case, and that the employed physician ought not to continue to have an obligation post-agreement to be responsible for the tail coverage. But those are just ways that can be allocated. Okay, now, the things we need to talk about is clinical and financial autonomy. And one to bring up is that employment setting invariably result in constraints on the physician's autonomy in terms of there's going to be a budget. You're going to have a budget, so by nature there's going to be a financial constraints, administrative, additions, what kind of equipment is going to be purchased, and so forth. Now in hospitals, AOs, physician groups, there's clinical protocols that need to be followed. And sometimes these may be national protocols, but sometimes they may be protocols that are simply developed by the group, like an integrated network or a ACO or a PHO, and those will dictate how that group, the kind of care, the kind of standards that group will conform to when it's treating its particular patient population. So that may circumscribe some of the employed physicians' clinical judgment. Also, when hospitals can often see physicians part of an overall business plan. So some hospital systems will be thinking more in terms of what is best for the system's bottom line. Along with that, then, may come certain constraints, such as limitations of referral patterns. We see some contracts that will say physician, you can only refer to the hospital-owned facilities for ancillaries and things like that. So, which I think I can also provide you with copies of the slide deck if you're interested. But I put some bullet points here to kind of serve as a checklist to help you think about this. I ask, we have endpoint of choice in selecting liability carrier? No, probably not, but it's a good question to ask. One of the questions, too, and actually some states have passed some laws on this. Texas passed a law, I think maybe 4 or 5 years ago. It was intended, they were seeing an erosion in some of their, Texas has traditionally a pretty strong position on the corporate practice of medicine, just that lay entities can't employ physicians directly anywhere, and the Texas market, because of move towards integration and things like that, we've seen kind of pressure to relax that. So in response to that, Texas has some legislation that was intended to provide physicians some additional autonomy protections. And one of these was to have the right to consent to settlement, instead of having an employer saying, physician, you need to settle, and then having that go into the data bank and something like that necessarily. So that's why I bring that up. About the role of clinical protocols, how are they selected in the group? How are they treated, or how are physicians generally going to be treated if, and their performance evaluated, right? Because if we're talking about value-based purchasing, compensation can depend on adherence to clinical protocols, whether they be process, organization, or patient satisfaction. How deviations that may be clinically necessary, clinically justifiable, how are those going to be treated? And so there are some examples there. Now, one of the very critical issues to talk about, and I think we're subsequent webinar is going to be talking about compensation. And there's a number of ways it can be structured. The point I want to emphasize to you is just be clear on what that is. Be clear on the methodology, whether it's base salary. We're not seeing much of base salary anymore. That's not news to any of you. Base salary, obviously, and then some sort of productivity metric. Definitely, I think in any system, it's salary within a work RVU, and we're seeing more and more now a quality component as well in that, like performance with respect to patient satisfaction metrics. But what that is, okay, you need to understand compensated, what your pay is going to be. So what's going to come out of that? Whether it's going to be, to what extent expenses, houses are going to be taken out in a portion to all the physician members, employees, offsets, penalties, and so forth. So here's a couple of good examples that Mark has drawn my attention to very helpfully. If you're a hospital and the hospital receives funds from the government, let's say under the Meaningful Use Program, and employed physicians have put a lot of sweat equity to be trained on that, on those systems, frustrations of those systems, right? Longevity because of those systems. To what end, though, will any of those funds be included in the physician's compensation, or should those funds be retained by the hospital or the other employer? It's an excellent question. We also know that under CMS rules, and also under a lot of private payer programs, there are financial penalties for too many readmissions, let's say per 1,000. Happens, for example, if your employer is a hospital, and it may take a pay cut for any hospital readmissions. All right. Well, to what will you finally financially responsible for those penalties? It's a situation where the hospital may say, look, you know, this is the responsibility of our primary care docs or surgeons or hospitalists, and push all the risk down on you. So you have to know that up front. Here are some more issues that you could consider asking in the context of going financial autonomy. What role do you have in hiring or firing? If you're working for a hospital, probably not much, if at all. Probably fall within the ambit of administration. If you're working in an independent group, might have significant latitude in that. When you buy in and be a partner or a shareholder, depending on how the legal structure of the physician practice is. This one's very important, especially and not only in the context of value-based purchasing, but also within the context of whether in a situation where the physician is employed in an independent practice and is eligible to buy in, partner or shareholder in the practice, on what basis will you be evaluated and how often? That's got to be transparent. It's got to be regular. If your compensation is based in part on performance with respect to metrics, process or outcome or patient satisfaction, you've got to know how you're doing. What you avoid are gotchas at the end of the year. All right? Whether you have referring to physicians or providers of your preference, we talked about that a little bit before. Say some of the hospital contracts might you have to refer for ancillaries to our facilities, even if you think you have a very good working relationship with a physician who's not affiliated with the hospital, or maybe maybe there's a really great facility you would prefer to do business with, et cetera. What you have with regard to purchasing needed equipment, let's say, for example, some hospitals will have lots with big vendors, maybe for implants or some other medical equipment, something like that. And then you will just use, that might be not a big issue for that particular specialty, but that is something to think about. The employed physicians probably oftentimes won't have a whole lot of discretion. What say we have over operational activity, for example, what codes are being used to bill for the physician services? That's a question that can be asked. Okay. We're talking restrictive covenants. We know this is a lot issue in many settings. And this is just an example of a covenant that I've provided you with. For those who are in employment for the first time, I think this might be useful just so you can see an example of it. I will tell you this is resources that the AMA have. Well, they have a number of good resources, but there's two model physician employment agreements. One is a draft employment agreement between a physician group and physician, and so it's helpful for both physician owners and for employees. And there's also a model annotated agreement between hospitals and physicians. And I lifted this. I think I lifted this from the medical group agreement. Okay, so agreement you're going to have this will apply post termination. Okay, there's a number of restrictive covenants that can be in an employment agreement. It may prohibit moonlighting during employment. This one is what I think people typically think about when they think about a restrictive covenant, that it prohibits certain limitations on a physician's ability to practice post-employment, period of years, and it also has a geographic limitation. Usually don't see limitations over 2 years. it's usually the geographic area that's more of a concern. So, now sometimes we'll see this, that a physician may be required to pay employers some amount of money in lieu of those restrictions. Sometimes that's an option. That's liquidated damages. You may see that in a contract. Okay. So one thing I want to bring up here, I've got it here as the second bullet point to make sure we don't forget about it. Employers are going to want to have that restricted covenant. And the main issue here is the which is going to be enforceable in the state law. Okay. This is going to vary just on a state-by-state basis. Sometimes the restrictive covenants are addressed in statute, sometimes just in case law. Okay. In most states, if they're done the right way with the appropriate something in exchange for value for the restrictive covenant, they are enforceable, but they also have to be reasonable. So in some cases, if they're not reasonable, depending on the state you're in, the judge may just throw it out, or sometimes the judge may rewrite it, okay, to make it more reasonable. Something out here is on the second bullet point. I think a physical protection that's really desirable. It's this: is that you're not going to probably get employment agreements out there that don't have restrictive covenants, but I think you ought to expect one to be in there. And if one is in there, unless the employer really wants you badly, very badly, it's probably going to stay in the contract. Okay, but put on this caveat that why to negotiate is that restrictive covenant, why, if the employer terminates the physician's employment without cause. Okay, so that the physician won't come to work with the employer. The employer says, look, we don't want to continue this. We don't have any real, we don't have, there's not an issue of non-compliance with the contract. There hasn't been a cancellation of a license or something like that. We just don't want to, we just want to keep going. Well, in that case, then here's the physician, maybe has moved his or her family to the community, terminated without cause, and what he or she going to do? Have to move or something like that? So I'd like to keep that in mind. So now, that's a restricted covenant that's triggered after employment. Restrictions during employment are generally valid. So these would say, for example, no moonlighting. We don't want you teaching. We don't want you researching. We want you to work only for us. Okay. Now, some physicians may not care about that. Okay. But the physicians who maybe are writing a book or doing research before they start employment, and run into a situation where the employer will say, hey, look, we've got the copyrights and all the royalties to any research or any copyright they form or that you execute with us. So, or they might prohibit that altogether. So I think what you want to do, and I've seen this from time to time, is go back to the employer and say, look, I'm involved in XYZ, research, moonlighting some other place, these other obligations, these opportunities I want to pursue. It's not going to interfere with employment, execute my duties with you, and have that carved out. A final note on restrictive covenants. Again, one advantage of talking with a lawyer is that she's going to know what the situation is in that particular state. So we've already talked about some of these caveats or limitations that may apply to restrictive covenants. Okay, so with regard to benefits, I just want to list some ones for you here. Just things you should keep in mind. They may not seem like a big deal, and frequently they aren't, but you might be surprised that sometimes something like CME or cell phones, something like that, may actually be kind of annoyance and might trigger acrimony between an employer and employee. You'll see, typically an employer will pay for a company car, cell phone, licensing fees, for society and staff dues. And two, you want to make sure that the tuition is paid for. And then also the traveling expenses as well. And sometimes there might be a cap, like $2,500 per year. But those are kind of stock issues. One thing I would like to bring up is with disability insurance, especially if you might be a surgeon. I wouldn't skimp on that, obviously. You really want to really think about with a financial advisor, depending on your specialty, with your proceduralist, about making sure that that's the skimp on that. So here's another checklist I wanted to give, maybe evaluate for that might come across your desk, whether you've been in practice for a while and are thinking about a change of venue, or whether you're just coming out of residency. Big plan you want to go with an employer. It'll help you evaluate an employer. The employer has a business plan. I mean, a lot of things are changing now in terms of healthcare delivery and payment. It's important that your employer, I think, done some thinking about that, and it may want to respond to changes, whether the changes are whether they're immediate, 5 years, 10 years down the road. In terms of hospitals, and do physicians have a voice in governance? What's its history with employees? In group practice, is a key physician about to move or retire? Right? In cases that can, especially for smaller groups, that can have a big impact. Employer able to retain its employees, and you can ask the employer in many cases. Let's say if it's a hospital system, you can talk to some of the other physicians there, the nurses. What turnover have you had? You can ask the employer itself that during your interviews. You ought to talk to potential colleagues, like I just said there. You also could talk to fellow residents about offers they're getting. It's thinking about an offer. One thing you do not ever want to overlook: spouse or significant other things. It might be easy to overlook, but for a physician, if he or she is going to be working a lot, but if the spouse isn't a physician or may not be working as much or have as demanding a career, or with the kids, it's that his or her situation is acceptable too. If not, then it's not going to work long term for you as a practicing physician. How much do you want to earn? It's really important, and it's good really to think about that, because we know about the issue about medical school debt. It may be really important. It's going to be really important that you have a sense of what you would to earn. So think about reimbursement, of course, and don't be afraid ever to ask the employer if the employer will help pay off student loans, recent expenses, things like that. And one good thing about when you talk with a lawyer about to help review the contract, one thing is going to help you find the right attorney with a lot of experience, and there's a way that we can help you find these people. That's also about what the market rate is, and they will also probably have a copy of the surveys like MGMA surveys. So those are some of the key questions. But these are all questions that you can answer, or at least get a satisfactory answer to help figure out if prospective employment is going to be a good fit for you. And here's the last slide. Just talks about some of the resources I've already brought up. Hospital group practice, model employment agreements. They're really good. They identify the hot issues. They're long, they're exhaustive, but they're really great issues. They're annotated. They have model language, the language you typically find in an agreement, but they have alternative language that might be of use to employed physicians, but also owners of physician practices might find them useful too. So send those to you. I think they're really excellent, and they were drafted by that have years and years of experience representing both physicians and physician groups. These are kind of the highlights that I wanted to cover tonight, and if anybody has any questions, I'll be glad to try to answer them.
Any questions for Wes at this time? Well, Wes, sometimes people are a little shy and are slow to ask questions, so I know I have one for you. I can tell you of a situation that we have heard of here in the state, and that's to do with the restrictive covenant. I understand the situation. It was a situation where, the physician was an employed physician, had been employed for a number of years, but then the compensation model had changed, and no longer happy with the compensation model, but then we're being held to the restrictive covenant. Now, is there something that a person can do in your employment agreement to have some protection against situations like that?
Yeah, question, Mark. In that situation, what I'm concerned there is that a unilateral change in something as important as compensation would constitute an amendment to the contract. At least that's a perspective I would take on behalf of that physician. So in that case, what I would always try to do in terms of amendments like that to the employment agreement is to say that amendments to the contract and anything else incorporated into the contract, like exhibits like we talked about, like change in duties or a change in location where the physician is supposed to be providing his or her services, compensation model. That change can only be effective if it's mutual agreement to the agreement. And so it's that there's language in there that prohibits amendment to the contract unless there's mutual agreement to both parties. That's what you would be looking for, and that's a reasonable position to take.
Okay. I did notice that we did have a few phones that were muted, so I just want to remind everybody that all phones have been taken off mute. Have any questions for Wes? Now is a fantastic time to ask him questions. He certainly has a wealth of information. So any questions for Wes at this time? Okay, Wes, hearing none, one thing I wanted to throw out there for you too is that tonight's presentations has been talking about your position as an employed person. But now, what would you say are some good takeaways if you're a physician with a group and you're looking to employ some newer physicians coming out of residency?
Okay. There's the things I would think about. And what you could do in this thing is you would take, when you think about being an employer, you want to have as much flexibility as possible. So, in terms of, you would want to have for-cause termination in there and without cause for all those objective reasons that list invested. You don't want to have a restrictive covenant in there to protect your business, okay? Because the physician owner is the one who, let's say we're talking about a group practice, and the group practice hire a resident, and so the physician group will invest considerable money in help building up the residents, the newly minted physician's practice. So the practice will typically probably want to have some protection in the form of restrictive covenant. You would want to make it reasonable, but you want it to be able to protect a legitimate business interest on the part of the physician practice. So I would say, from the employer standpoint, you would want to have, make it this way. It's good to have the clarity on the issues we raised, because so often a lack of clarity leads to a lot of troubles down the road that are not only difficult maybe for the employed physician, but also for an employer group. So it's good to be clear on compensation models. It's good to be clear about restrictive covenants. But I think in terms of looking forward to hire, you certainly want to look for someone who's going to be a good fit into the culture. And I know that can be challenging, because I know there's some demographic differences as well. So someone who comports themselves very professionally, someone who's done research into your group, someone who is reasonable, right? Trying to find a reasonable solution to any negotiated points. Someone who doesn't come back if the entire contract redlined, okay? Someone who's kind of identified some of the top 5 or 6 things they'd like to have discussed, maybe will be satisfied with 3 or 4 of those, okay? Someone who's treating not only the physicians well, but the support staff well. So someone who is always reasonable, always professional, researched your group, researched the community, and comes with questions and knows what he or she wants. That's the person I think you want for a professional. Someone who is interested in the business prospects of the medical group as well. How's it going? What's your strategic plan? What's your business plan? Someone who wants to impress you and who would appear to be invested in the practice and would show an indication that he is interested in the long-term investment.
Any other questions for Wes? At this time, Wes, if somebody does have a question, is there a way that they can reach out to you to follow up with anything from tonight's program?
Yeah, by all means. What would you all prefer, phone number or email?
Okay, go ahead.
Email. So it's WES, it's just my name, Wes Cleveland, Wes.Cleveland, AMA-ASSN. And we're all night.
Perfect. Thank you, Wes. Truly want to say thank you for taking your time to be with us. This was an informative program, certainly gave me a lot to think about. And I confess to the group, I had an advantage. I was asking you some questions back and forth before we got to tonight's program, so it's invaluable. For those of you that have attended tonight, please note that there is Category 1 CME credits available, so when you log off the website tonight, you will be taken to a website with the Sanford School of Medicine, which you can register for and claim your 1 credit of Category 1 CME. Please note our next program in this series is scheduled for Tuesday, July 12th. That program will focus on compensation and benefits. So with that, if there's no further questions, thank you all for participating and ask you and encourage you to have a good evening. Thank you.